I get asked this question all the time. How do I defend people who I know are guilty? And oftentimes my answer is not what people are looking for, but it's the answer. So what I tell people is that I and criminal defense attorneys in general am very comfortable with the fact that there's very little that I know. What does it mean to know something? And some people think that I'm getting cute, but truly, to know something, I have to have quite an amount of evidence to actually know something. So I can strongly suspect that a client did what they are accused of. I might have a sense that that is the most likely thing, that they did the thing that they're accused of, but I don't know that they did the thing. The other thing I think about is the presumption of innocence. Everyone is presumed innocent until proven guilty. And if I, as a criminal defense attorney, cannot apply the presumption of innocence to my own clients, we have a really big problem. And so I do, in fact, presume my clients are innocent. And even if there is strong evidence that they're not, they haven't been proven guilty until they go through the process of a trial, and either a jury or a judge, depending on whether it's a jury trial or a bench trial, has found that the state has proven them guilty beyond reasonable doubt. Until that happens, they're presumed innocent. So when I get up in trial and I say that my client is not guilty, that is true. They are not guilty until proven otherwise. There's no lie there. And then at the end of the trial, when I'm arguing that the state has not succeeded in proving its case beyond a reasonable doubt, I get to say that my client is still not guilty. And because the presumption is a presumption of innocence, I call not guilty innocent. And that makes my job easier, frankly, to be able to rely on the presumption of innocence and holding the state to its burden. But when people ask me the question, what they're really asking is, how do I get over that concern that my clients did the thing that they're accused of? And frankly, I don't concern myself with that. My job is not to worry about whether or not my clients did the thing they are accused of. My job is to help preserve their rights and pursue their interests. That's my job. Now, there are ethical restrictions. I'm not allowed to lie. I'm not allowed to present false evidence. But as long as I'm able to defend my clients honestly and ethically, that's what I'm going to do. So I don't really concern myself with whether or not my clients did the thing that they're doing, that they're accused of. However, I will say this. If my clients insist that they did not do the thing they were accused of, and the evidence is overwhelming to the contrary, I'm going to have a very frank discussion with my clients about that. Because ultimately what I am worried about is what the state can prove. If the state can prove its case beyond a reasonable doubt, my client really does not want to take their case to trial, because that's going to be bad news. They're going to have a bad outcome. And so part of my job as a criminal defense attorney is to have candid, frank, and sometimes hard conversations with my clients, explaining to them the realities of their case. And what I also had to tell my clients is that if I, as their attorney, don't see the path to a not guilty in the trial, the person who's signed up to be on their side, how can we expect the fact finder, be it the jury or the judge, to do that? And so it's not so much that I have a hard time representing people that I see evidence for the fact that they did what they're accused of. It's more, how do I represent people where the evidence is overwhelming that they are guilty of what they did? And sometimes that's the trick, right? Sometimes that's the real job. How do we do it? How do I come up with an argument for a client where the evidence is overwhelming? And sometimes all we're doing is holding the state to its burden, playing for the fumble. That is something that happens often. My colleagues will often refer to that as the slow guilty plea. And sometimes you have to do it because although it is the defendant's trial rights, the defendant is the one who has the right to take the case to trial. The state doesn't have that right. If the state doesn't give the defendant a sufficient incentive to not go to trial, then we're going to go to trial. And by that I mean, if the state doesn't offer some alternative to going to trial, the defendant has no reason not to go to trial, or at least on its face. Sometimes defendants just really don't want to go through the trial, and they might short circuit the process by pleading guilty, but I rarely will tell a client to do that. Because oftentimes there's no benefit to doing so. The trial is meant to protect their rights, and sometimes good things can happen, even in a case where the evidence is overwhelming. So that's the answer. Let me know if you have any other questions about this, or if you disagree, or if you've had an experience with an attorney who represented you, even though the evidence was really hard against you, or something similar. I'd be very curious to hear what your experiences have been. And don't forget to subscribe and follow and like and share this video with anyone you think would be interested, and I'll catch you guys on the next video. Remember, you have rights, they matter, protect them, be safe. And like I said, I'll see you on the next video.